And Mr. McCoy, you're up. We'll continue with your direct. And have you sworn him in already?
I swore him yesterday.
Okay, and Mr. McCoy, my understanding is that you are your next witness, is that correct?
That is correct.
And you have been sworn in, so I just remind you that you are under oath.
Okay. My name is David McCoy. I'm the Executive Director for Citizen Action New Mexico, which is a 501c3 organization. We've been active in the matter of the mixed waste landfill since approximately year 2000. I have been present since July of 2006. We have a website at www.radfreenm.org, and we have many scientific articles and analyses of environmental matters, both for the mixed waste landfill and some other hazardous waste sites in New Mexico, notably the Kirtland Air Force Base, where there's a massive jet fuel spill. I am a licensed California-based attorney, California Bar 170737. I do not have a license in New Mexico. I've appeared at negotiations and hearings for the chemical waste landfill. I've filed numerous technical comments previously, along with registered geologist Robert Gilkison and Dr. Eric Nuttall for many phases of the MWL corrective action process. Those technical comments are a part of the administrative record for at least my comments. There's other comments from Citizen Action that predate mine, but I've filed comments for the administrative record for the mixed waste landfill corrective measures implementation plan, the implementation report, the long-term monitoring and maintenance plan, and the current corrective action complete. I filed a complaint along with a registered geologist, Robert Gilkison, with the U.S. Environmental Protection Agency, Region 6, about the defective groundwater monitoring at the mixed waste landfill, and that basically had the result of the installation of 4 new monitoring wells at the mixed waste landfill. I filed FOIA lawsuits against both the United States Environmental Protection Agency, Region 6, and the United States EPA Office of Inspector General for documents that were pertinent to the mixed waste landfill. I filed a FOIA lawsuit against the Department of Energy for documents that were related to the mixed waste landfill. I've met numerous times with former Secretary Ron Curry and Ryan Flynn regarding the mixed waste landfill. I've devoted nearly a decade trying to convince the NMED and DOE to clean up the mixed waste landfill. So I'm not loved by anyone particularly in all of this. The Freedom of Information lawsuits were brought against the DOE, NNSA, Sandia for failure to provide documents pertinent to the mixed waste landfill and 10-year site plans. I've appeared on several occasions before the New Mexico Legislature, the Albuquerque-Bernalillo City Council, the ABC Water Protection Advisory Board, the Water Utility Authority regarding both the mixed waste landfill and the Kirtland jet fuel spill. I introduced the resolution 15-7, which was passed by the ABC Water Utility Authority, requesting DOE to answer allegations regarding high-level waste disposal at the mixed waste landfill. I've also introduced memorials before the New Mexico State Legislature in the 2014 session. This year, and I think at the tail end of 2014, Citizen Action brought to the attention of the New Mexico Secretary and the staff the thousands of radioactive and toxic material disposal sheets that were not previously considered by the New Mexico Environment Department for the current corrective action complete application. Prior to my position as the Citizen Action Director, I collaborated with non-governmental organizations, environmental organizations, to achieve shutdown of 2 nuclear incinerators at the Idaho National Laboratory that did not have RCRA operating permits. Before that, some of the other fun I had was getting secondhand smoke and smoking out of the California State University system, California. I was the first person to ever take a lawsuit to the Supreme Court of California that said non-smokers should have the right to a smoke-free workplace. They threw it out, but we still got it out of the system anyhow. Anyhow, those are some of my qualifications as a troublemaker, and today, after listening to 3 days of rebuttal testimony, I almost feel like I'm ready to be cross-examined without testifying by Mr. Wexler. Anyhow, I'd like to proceed to my basic testimony.
Okay, before you do that, you did file pre-hearing testimony, is that correct?
Yes, I did.
Okay, and is that still true and accurate testimony today?
I believe so. I do not intend to religiously follow it, however, because a lot of it has previously been covered by witnesses, so I hope you'll forgive me hopping around a little. You won't be able to necessarily follow it. And I do want to mention right at the beginning here that in the second paragraph of that pre-filed testimony, I stated that Exhibit 1 and 2 are included in their entirety herein in this testimony. So I will be going largely to some of that information, and I hope that's not too objectionable.
Okay. Do you offer your testimony at this time for admission?
I am. Thank you.
Okay. Objections? With no objections, it is admitted, and you can proceed with your presentation.
Okay, and I'll try and summarize, the basic issues that I think are applicable here. I want to put out right at the forefront of this that a lot of discussion has been had during this last now 4 days regarding things that were put in the record or things that were missing from the record, and how much DOE went out of their way to put things in the record, and whether or not people saw those things or understood those things is somewhat contentious. At any rate, RCRA, the Resource Conservation and Recovery Act, requires that if there is omission of information or new information that comes along, that information is supposed to be incorporated, okay? And if the record's incorrect because of information that was omitted, or information that was incorrect, the record is supposed to be, corrected. And that hasn't happened to a large extent with the mixed waste landfill and things that have been discovered over the years. One of the things that is our primary contention is that the cover for the mixed waste landfill cannot be protective of public health and safety for the reason that there are considerable amounts of high-level mixed nuclear waste that were disposed of in the mixed waste landfill. Now, while the definition may be in contention, the DOE Order 435.1 talks about high-level radiation, high-level waste being that which needs to be permanently isolated. And they're in the document SAND 2010-6335. There is on page 17 a statement that there was a lawsuit by the Natural Resources Defense Council which resulted in the need to more thoroughly apply that definition to high-level waste. The Nuclear Regulatory Commission also talks about, in a document that Dr. Nuttall furnished yesterday, speaks to that same concept that high-level waste is that waste which needs to be permanently in permanent isolation for the purpose of public health and safety. Now, a lot of this business about the high-level waste, how did I arrive at that? Well, I want to show you, there's two boxes here. These two boxes.
Yeah, we have a bike rack outside, but they're not allowed in the museum. Thank you.
Thank you, ma'am.
Thank you. I'm sorry.
Okay.
These two boxes here were obtained under Freedom of Information Act, and I don't think anybody really bothered to go through them until I found them kind of in the back of one of the offices where a bunch of documents were being stored. And what they have is, in these folders anyhow, is year by year radioactive and toxic material disposal sheets. And I spent about 6 weeks going through these sheets. And I don't think anybody else in this room has ever gone through these sheets. And I'd like to submit them into the record. I don't know how to do that exactly, because I can't afford to make copies of all these documents, but here they are. And the documents are quite distasteful to go through. They have disposal sheets for, well, just grabbing this top thing here. Here's 1,400 pounds of depleted uranium-238. Here's depleted uranium-238, 180 pounds from the Kwajalein atomic bomb tests. Here's stuff that indicates pins in pit 33. So you go through these documents, and there's literally thousands of them. We did put one entire box on our on a Google Drive site, and I sent out all of you who are parties have access to that site. And I did send out a link previously to link to all of these sheets. So they actually are in the record to that extent. Now, in looking at these data sheets and comparing them with the inventory sheets, you find a lot of items that aren't listed in that inventory sheet. Now, the inventory sheet, the summary sheet, and that's Exhibit 11, I think, for citizen action, cannot possibly encompass what are thousands of data sheets. You can't have an accurate record in relation to the data sheets. And during the years, I believe about 1960 to 64, apparently there was some records purge where there are no records of things that went into the mixed waste landfill. So it makes the record even more spotty with respect to the data sheets.
Do you mind if I ask you a question before you move on from this?
Sure.
When was the FOIA request made, and if there were multiple FOIA requests, when were they made?
Well, the FOIA request was made before my time, and I think somewhere in the time period of 2000 to 2001, perhaps.
Okay, thank you.
And then there was subsequent follow-ups to that, and even a lawsuit, I believe, that fell on the heels of still not getting information that was requested in the FOIA. So this information is really crucial to what's in the mixed waste landfill. And one of the documents that we obtained from FOIA is a United States Energy Research and Development Administration document from September 8th, 1977. One of the things it mentions is that on page 10, it states currently all radioactive waste generated at SLA, that would be Sandia Labs Albuquerque, is buried at SLA. This is accomplished according to formal policy and written procedures by health physics personnel who receive the waste at the point of origin and check for proper packaging, identification, and labeling. Okay, so the mixed waste landfill was your main dump for radioactive waste, hazardous waste associated with that at Sandia Labs. On page 11, it states detailed records of all waste disposal activity since 1964 are microfilmed and are available. Well, it'd be nice if DOE would put that in our record. Then we'd have all of this on microfilm. So it says all records prior to 1964 were destroyed as part of a records purge. Yesterday, Paul Robinson testified, and he spoke to the issue of the soil vapor monitoring and the contamination that's been discovered beneath the mixed waste landfill, and the VOC contamination, volatile organic compound contamination, has been one of Citizen Action's concerns, and we're discouraged to see it now showing up without any kind of corrective action surrounding that. When the fate and transport model was being made about this matter, Citizen Action became aware that there was a document written by Tech Law which had been furnished to the New Mexico Environment Department. Citizen Action wanted to get a copy of that, and this was just a few months before I came on as director. And so in February of 2006, there was a letter from Sue Dayton, who was then director of Citizen Action, to John Keeling, and I passed that out before the hearing. I don't have an exhibit number on it, but I do want to submit it as an exhibit. And it is basically asking for the Tech Law report. It says, we understand that Tech Law will be reviewing the CMIP, Corrective Measures Implementation Plan, and the Fate and Transport Model, the state's reliance on an outside contractor to review the CMIP and FTM, as well as review public comments. We would like to request that the NMED convene a technical discussion group with SNL representatives, NMED, and interested stakeholders to further evaluate both studies before the CMIP and FTP are determined to be complete by the NMED. We would also like to request copies of Tech Law's review and comments on the CMIP and FTM, including their comments on any revision of studies. Now, obviously, this document was something that would have been useful to the public and which the public should have had. If you look at regular law, requirements are that the public be on an equal footing with the regulatory agencies in respect to the information that's available, and that has not been the case for some time. Now, when I heard about the Tech Law document, I said, where is this thing? I don't want to look at it. And they said, oh, well, we've been told by the Environment Department you can't have it. It's executive privilege. I said, nonsense. Wrote the Attorney General. Attorney General told the NMED twice, it's a public record, give it to Citizen Action. They refused, filed a lawsuit against Citizen Action. And I know you've heard this story before, but the story is that this Tech Law document was important at the time because it was highly critical in numerous respects to the Fate and Transport Model. And if citizens had had this kind of document in their hands, it would have been very useful for them to raise numerous issues about how the Fate and Transport Model had been written and that sort of thing. Well, it took over 3 years to get this document. We finally obtained it. In another part of this difficulty in obtaining information, and I'm not going to go into all of the details, but I've discussed these items in my Exhibit 1 to some degree, and in 2007, Robert Gilkison, who's a registered geologist and Citizen Action, filed a complaint with the EPA Region 6 about defective groundwater monitoring at the mixed waste landfill. And the complaint, the elements of the complaint had been previously brought to the New Mexico Environment Department, and which ignored these things and didn't really give us any kind of responses that would indicate that they were going to correct the record or take any steps to change the situation. Now, here's the part that is so negative in all of this, is that the items that we brought to the attention of the EPA had been written about in at least 6 different reports filed in the 1990s. And it was clear that the mixed waste landfill groundwater monitoring network was a defective groundwater monitoring network. Within 2 years after the discovery of, or after the placement of the mixed waste landfill monitoring wells, BW1, MW1, 2, and 3, it was discovered that the direction of groundwater was not to the northwest, as Sandia had put forward, so that you had your monitoring wells in the wrong location. You had MW1 and MW2 on the north side of the mixed waste landfill. You had MW3 over on the west side, which was the only well that was properly located. The background monitoring well was to the southeast. All 4 of the wells had been constructed with stainless steel well screens that were corroded, and they knew they were corroded, and corrosion interferes with the sampling and whether you're getting reliable and representative samples. There were other problems with these wells, and all of these problems were brought forth in the 90s, okay? And one of those other problems was they used mud rotary drilling methods. And when you use mud drilling with bentonite clay, that absorbs the contaminants of concern. And so you're not getting reliable sampling. Well, they took the data from this groundwater monitoring network, and they provided that data as the Department of Energy provided, Sandia provided that data to state that there was no evidence of contamination to the groundwater at the 2004 public hearing. Well, how could you have evidence of groundwater contamination? You might as well have been monitoring on the far side of the moon because your stuff was out of position. That wasn't corrected in the record. Work was never informed of these documents that indicated there was not a reliable groundwater monitoring network at the mixed waste landfill. The hearing officer was never informed of these problems with the groundwater monitoring network. As we went through the documents in late 2006, Robert Gilkison had already identified that there were problems with this groundwater monitoring network. As we went through the administrative record, we saw these earlier reports and went, my God, they knew that they had these problems and they didn't do anything about it. And so we raised the issue and finally went to EPA Region 6. So EPA Region 6 took a look at it, and in 2007, they sent an email to Mr. William Motes here and identified problems with the groundwater monitoring network and informed them that several monitoring wells needed to be replaced, okay? We couldn't get a hold of any of that information. We knew that there was a technical report that had been written by EPA Region 6. I called one of their attorneys. They said, oh no, there's no technical report. And so I filed a Freedom of Information Act request and ultimately had to go to federal court to get the report. The EPA Inspector General, however, did file a hotline report talking about the technical report that had actually been done and that the 2 hydrologists and a geologist had agreed with our concerns in many respects about the problems with the mixed waste groundwater monitoring network. Well, those earlier problems with the groundwater monitoring network were never put into the record, were they? the defective groundwater monitoring wells that were used. That wasn't put into the record. It wasn't corrected. That the data was not really what was needed. So anyhow, we did get that technical report somewhere in a couple years after the Inspector General had informed us that there was such a technical report. So in getting information about the mixed waste landfill, it's been like pulling duck's teeth. Very difficult. And with respect to these documents here, I want to go back to these documents. And the time I spent reviewing them, I spent approximately 6 weeks going through these documents, putting little flags on things that were interesting. I did this for all of them. This one here seems to be more about the experimental side. This box here is more about the military side. In these documents, as Dr. Nuttall pointed out yesterday, you find references to different acronyms. And unless you know what these acronyms mean, you don't know where this waste is coming from. You would never be able to know that it had come from nuclear meltdown experiments. We were able to look at the 4 memoranda contained in Exhibit 5, Citizen Action Exhibit 5A through D. And looking at those records, we found canisters that had been disposed in pits 35 and 36. Well, that had been somewhat known. And in examining these documents closely, we noticed that there was indication that other canisters had been buried in other trenches at unknown locations. And so when you look at the inventory list, you don't see that. When you do see the 4 canisters that were disposed of in pits 35 and 36, but you don't necessarily see evidence of these other canisters that were mentioned in this memo. And this seemed to have been a methodology of disposal, as was shown from the 2001 or 2 database for excess materials. There was a 15C that indicated that now that we can't, we're between a rock and a hard place for disposing of some of this stuff, and it was, Mr. Strong indicated that was definitely an implication that these canisters had previously been disposed of in the mixed waste landfill at other locations. So that's, without the disposal sheets, without looking at the 4 memoranda, without going online and looking for these different kinds of experiments that were conducted, it wouldn't have been possible to relate some of the waste to the experiments. Now, the lucky thing was I was able to collaborate with Dr. Nuttall on this. And he had already done a little bit of work on this, and so we began really looking at what some of these experiments were. And you had numerous different acronyms: EEOS, TRAN, DF, D, FD. when you get all these acronyms and you don't know what they mean, but you see disposal related to them, you don't necessarily know where that disposal is coming from. But then once you find out that these acronyms relate to nuclear meltdown experiments, it gives you a whole new insight. Now, DOE can argue, well, you should have understood all of that before, but DOE didn't go to the Work Commission and say, hey, we conducted nuclear meltdown experiments, we got irradiated pins, we had fresh fuel pins from around the world, and we put them into a nuclear reactor, and yeah, we cut some of this stuff up, and we had a lot of debris from it. Some of that debris went in the mixed waste landfill. That information was not provided. And when Dr. Nuttall tried to raise this issue, the hearing officer was doubtful that NMED with the Kennett report had adequately investigated this matter. And I'm going to get a ton of cross-examination about this. But that's just the way it is. The information was not really furnished. Okay, what's the bottom line on all of this? The bottom line is that you disposed of high-level nuclear mixed waste into the mixed waste landfill. You presented the mixed waste landfill as a low-level mixed waste dump. And you want to put a cover over it now. And you want to say that the cover is adequate to protect public health and safety. Well, it's not adequate to protect public health and safety against the type of waste that were put in here. And those are high-level nuclear waste. Now, if you don't want to use the definition of high-level nuclear waste, well, let's talk about should people be exposed to plutonium? Is plutonium already in the groundwater? Yeah, it looks like plutonium-238's already in the groundwater. If you take a look at your own Phase 2 RCRA facility investigation, on page 4-144, it talks about how the boreholes found plutonium-238 and 239 present at 50 feet, 70 feet, 89 feet, 200 feet, 499 feet, and 546 feet. Now, how do we get ourselves off the hook? Well, we say when the MWLF soil samples were analyzed, Quanterra, formerly NSECO, had just begun operation of their mixed waste laboratory. So they couldn't have possibly been analyzing this data correctly, okay? That's the implication here. We couldn't really have plutonium at those depths. Well, did you go back and reanalyze all this? I don't know. But this is sure an indicator that from borehole samples, you've got plutonium down at the level of the groundwater. Now, we talked about sodium being in the mixed waste landfill, metallic sodium that was associated with the meltdown experiments. So on page 4-103, table 4.6-5, tau metals detected in borehole soil samples, it talks about sodium. And when you look at the reference for sodium, it has a little C next to it in parentheses. And it says about metallic sodium that the metal is considered an essential nutrient as described in RAGS, parent EPA, 1989 parent. An essential nutrient. I'm sure we'd all like to sprinkle a little metallic sodium on our breakfast cereal in the morning and listen to snap, crackle, and pop. Anyhow, so this is the kind of thing that we're concerned about. Accidents out there. You've had 2 uranium fires. Hey, while those uranium fires were going on, did anybody run out there with a smoke detector and say, hey, look what's coming off of this mixed waste landfill going into Albuquerque's air. Anybody do that? Were there any studies of how much radioactive material was released? I've never been able to find them if there were. A little bit after that uranium fire, they plopped an entire fire engine into a trench that had been dug to hold the fire engine. I mean, there's just some amazing stuff when you go through these material disposal sheets. And some of those things are, they're mentioned in your inventory, but there's a lot of things that aren't in that inventory. And going through this stack of documents compared to going through a few pages of that summary inventory is a completely different experience, folks. Let me assure you of that. Beryllium, large amounts of beryllium were put into that mixed waste landfill. There's plenty of toluene. When they found toluene a year or two ago, it was determined to be laboratory error. Well, it was lots of toluene in that dump, but that was not really. Who knows if it was properly investigated or not? Now, yesterday we had a lot of discussion from Paul Robinson and the Department of Energy and the Environment Department about the monitoring with the vapor monitoring wells. And those are what they call flute wells. And in February 26, 2008, the New Mexico Environment Department, in discussing material disposal at Area H at Technical Area 5 up at Los Alamos National Laboratories, took a look at the flute system. And their concern at the time was that the flute systems are only, it says, NMED contacted the manufacturer who acknowledged that there were problems with VOC absorption in flute systems greater than 50 feet in length. NMED is concerned that the material used for the construction of the membrane may have absorbed some of the VOCs or influenced contaminant detections in other ways. NMED therefore directed the permittees in a 2007 letter to evaluate the effects of the flute system on VOC sample measurements. Well, I've never seen the evaluation of that, but after we found this letter, we had written to the New Mexico Environment Department and said, hey, you're planning on using flute wells out there, and it looks like from this memo from your Hazardous Waste Bureau chief that they're not effective after 50 feet. Well, okay, so I haven't heard any resolution to that problem. So we're finding VOC contamination in the form of PCE, TCE at these 400-foot depths. So that's great. We've got some kind of detection that we're looking at, but is that an accurate detection? Are we not back at the same type of situation where we had defective groundwater monitoring wells? Where, Mike Barcelona yesterday, Dr. Barcelona, talked about shining a flashlight into a forest and how much you were going to see. Well, how much you're going to see depends on the accuracy and of your, if you've got weak batteries in the flashlight, you're not going to see very much. If it's a small flashlight, you're not going to see very much. And if you've got defective ground monitoring wells and you've got flute wells that aren't adequate to the job, well, you're not going to know the full extent of contamination. So the levels of contamination at 400 feet could potentially be larger if the flute wells, in fact, are not an adequate monitoring device at depths greater than 50 feet. Now, I'm not a a technical person, but I can read English, so it does arouse one's interest in that sort of thing. After looking at this for, 9 years and filing comments and numerous technical comments and collaboration with Dr. Gilkison and Dr. Nuttall, it all begins to look like something that isn't safe for the public. It doesn't matter if you constructed a cover. That's a great cover. You've already had 270,000 gallons of water disposed in one of the trenches there. The list of radiological contaminants in that were quite interesting. You've had 5,000 gallons dumped in a trench to put out a uranium fire. The second uranium fire was put out with carbon dioxide gas, I believe. And then you've had storm water going over these pits and trenches for decades. One of the, I believe I maybe put it in the rebuttal to Mr. Mitchell's testimony, I'm not sure, but there was evidence of the concrete caps on the pits being in such disrepair that water rushed into them, and that was described by John Gould. You had 8 inches of rainwater pouring onto the mixed waste landfill every year. You had unknown amounts of liquid waste disposed of in the mixed waste landfill, and I listed some of those in that rebuttal sheet. There was heavy water, deuterium, that kind of thing, put into the mixed waste landfill. So, and then the VOCs, as Paul Robinson correctly pointed out, when you go through these sheets, you see an awful lot of sheets where it'll say, metal cuttings. Well, when you cut metal, you're going to be using some kind of cutting oils, that kind of thing. But it'll just say debris, cutting metal debris. So you don't really know with any exactitude what it is. So you don't really know how much different types of liquids were put in there. But I can tell you from at least 1959 to 1962, all of the types of chemicals that were subsequently put into the chemical waste landfill were put into the mixed waste landfill. And you had this tragic plume of contamination at the chemical waste landfill. And now you're beginning to see the beginnings of the plume at 400 feet. You've got the plume at Tijeras Arroyo groundwater. How far does the NMED intend to allow these types of things to develop without first going in and remediating them? I mean, that is the primary way to protect the public. You don't go in afterwards and say, oh, well, we put a cover on top of it. Let me get this straight. Here's the cover, here's the waste and liquid and chemicals, and here's the groundwater. Is there anything between the pits and the trenches? No, they're totally unlined. Is there anything that's going to stop that movement of gravity 24 hours a day to the groundwater? No. What are we going to have to get out of this dilemma? We're going to say, oh, we're going to impose trigger levels. Trigger levels. When I think about a trigger, I think about a gun pointed at me. And that gun is pointed at the Albuquerque public in the form of one of the most unique and highly dangerous toxic waste dumps, toxic and radioactive waste dumps in the entire United States. There was no other place where they were doing these kind of meltdown experiments like they were doing at Sandia Labs, you know. And I've only focused on that side of it. You go through here, and I began finding these odd names: Diana Mist, Hudson Moon. What is this? Husky Pup? Husky Pup, there's one that lives behind me in the alley. Anyhow, it turns out they're all nuclear weapons experiments. And they brought whatever they brought to Sandia, did experiments on it, and then disposed of it. Now, some of that stuff is in the inventory sheets, but you'd never know what it was by the odd names they gave to it. That's kind of a summary of my testimony, and so it's Saturday, and things could go on a lot longer than this, but I'm going to stand for cross-examination. Thank you.
Before you do that, you did already present 12 exhibits, so as Exhibit 13 will be the February 7, 2006 letter from Susan Dayton. Any objection?
Could we start that at maybe about Exhibit 17 or so?
Let's call it Exhibit 17. That is Exhibit 17. Exhibit 18 will be February 26, 2008 letter by James Biarzi, I'm sorry, to Misters Gregory and McEnroy. That will be Exhibit 18. Any objection? With no objection. Exhibit 19, September 1996, report of the mixed waste landfill, Phase 2, RCRA facility investigation. Any objection? Okay, so with that, those three exhibits are admitted. We will move to cross-examination. I encourage the parties to bring up new issues or address new issues. We have been here 3 days, more than 3 days now, 3 long days, so I have heard a lot of testimony. I just strongly encourage the parties to address new issues instead of repeating things that we've heard several times now. So with that, as always, we will start with friendly cross-examination. Dr. Nuttall.
Hello?
There you go. Yeah, you just pointed toward you.
Okay. In the records that you saw of the disposal sheets, did you see cases where they disposed of uranium, sodium, and fission products? And I have an example of one of those if you...
Well, let's let him answer the question first before you give him an example.
I saw numerous examples of the disposal of uranium-235, uranium-238. Many of the disposal sheets, when they list this, they simply put DU-38 or U-235. They use shorthand abbreviations. Oftentimes, these disposals were combined with multiple fission products. In most of the examples of the sodium disposals that I found, and I've listed many of those, there was evidence of multiple fission products combined with that. And some of the disposals of depleted uranium were enormous. I saw a disposal up to 6,000, 8,000 pounds at a time of these kind of U-238.
Was there a memo, a FOIA memo that said that it was no longer possible to dispose of packages containing sodium?
It wasn't a memo. As I recall, it was a excess materials, let's see, it was from 1984, as I recall. I had a exhibit to that effect. Well, that was the portion of the FOIA document that discussed that type of waste and indicated that it had previously been going into the mixed waste landfill, and that now it would be considered mixed waste, and that they were kind of between a rock and a hard place, and they were going to have to discuss this matter further with DOE.
And in this document, they talk about packages. Can you explain the difference between packages and canisters?
Packages were used more to reference the kind of what the experiments were put into. In other words, these experiments for the meltdown tests had fuel pins in them, and oftentimes had an elaborate arrangement of mirrors and electronic equipment, and they would take photos of this. It was really pretty clever. They'd take up to 1,000 photos a second of what was going on during the meltdown of this fuel. And so that was the contents of the package.
So in this memorandum, it says that it's no longer possible to bury packages containing metallic sodium. And when we refer to sodium, is it correct that there are a multitude of data sheets that show the sodium being radioactive and containing multiple fission products and uranium?
There are, and I enumerated many of those sodium disposal sheets by date in Citizen Action Exhibit 1, and also yesterday I handed out a sheet that had several sodium disposals on them.
And where does uranium and radioactive sodium and mixed fission products come from? I mean, how are they generated, or?
The only way you're going to generate radioactive sodium in the instances that we're looking at would have been in relationship to the experiments that were conducted for the LMFBRs, which was a liquid metal fast breeder reactor program. On page 29 of Exhibit 1 of Citizen Action, I listed many of the disposal sheets for sodium that show sodium, along with the multiple fission products that would have resulted from the experimental meltdown tests.
And when they talk about disposal of sodium packages with these mixed fission products and uranium, do we show on the data sheet anything about the mass or quantity of material that might be in there explicitly?
No, they don't show, but in my review of some of the technical aspects of the experiments, there were up to 2.5 kilograms of metallic sodium that were used in these experiments, and that was confirmed yesterday, or the day before, I guess, by Dr. Farnham, that at least in the D10 experiment, that amount of sodium was used.
So we talked about packages and canisters. Other than the 4 canisters that went into pits 35 and 36, is there any reference in the FOIA documents to canisters elsewhere located in the mixed waste landfill?
There is. There's in the February 20th, 1997 memoranda, which I believe would be Citizen Action Exhibit 5A. There's mention of the canisters having been disposed in small diameter vertical holes drilled into the bottom of trenches, but there's no specificity as to where those were drilled. And it makes sense that they were drilling those kind of holes because the memorandum mentions both a drilling rig, which just happened to be unavailable for the disposal of the canisters in pits 35 and 36, and so they were disposed there rather than being put into the trenches. There was also mention of a crane on site at the mixed waste landfill, and that some of these materials are pretty heavy, and since they're also highly radioactive, you wouldn't want people getting, it's not something you can handle and just drop in the hole. The radiation levels are much too high. So,
let me go on. Do you recall a FOIA document that talked about mummification of canisters, and that some were very hot, and that it could be by cross-contamination out on the outer surface? And if so, I'm not quite through with my question. Okay. And if so, how does that contamination, and presumably radioactive because it was mummified, and we talked about the definition of having to shield, where could that contamination have come from in those experiments?
it seems that quite a few of the experiments had what they called post-mortem examination. It was usually referred to as post-mortems. That's another thing, when you're looking at this, you see post-mortems and you think, well, maybe this is where Jimmy Hoffa was buried. But in these post-mortems, they would have to be conducted in the hot cell facility, and they would have, it mentions arms and fingers, which are not people's arms and fingers. They're mechanical manipulators that are cutting this material up. You've got a primary canister, a secondary canister, and as they would cut this material, you're going to get contamination from the internal part of that package on to these containers. And so this material is quite hot radiologically. In other words, got quite a bit of curies involved. The mummification process is something they would do before disposal. I'm not sure what all it really was to protect against. Maybe loose material getting out, to maybe just to hold the cut-up package and post-mortem debris and that kind of thing together as a unit. So I don't know if that helps you.
Yeah, if your number of the data sheets talked about induced radiation from cobalt. Cobalt, if it's present, which it shouldn't be in the stainless steel, but if it is, because there's two parts to this question, so would that constitute the loose material on the outside, or is the loose where do you think the loose radioactive material could have come from if it's not from the activated cobalt? What would be a logical explanation? Is that at all clear? That was kind of
the questions? It's really one question, I think, but which is where do you think,
Well,
what's the source?
Are you asking where the cobalt would have come from, or where the other?
Well, I'm
material-
trying to separate between the cobalt activation that was common on the data sheets, as shown as some of the radiation came from cobalt activation. Cobalt is intimately...
Start with the first question. Just start with the first, well, let's just break it down. I know you said you have multiple questions. Let's just ask the first one, and then we'll...
Okay, if I could break it into two questions, maybe
Start
that's...
with the first, yeah. Let's just do it that way.
Could cobalt that's contained within the steel itself and become radioactive account for the loose radioactive material on the surface of the stainless steel canisters?
Perhaps if it was part of the cuttings that were left after the postmortem debris, if the entire canister is being disposed of, you're still going to have the materials that are in this package, as they like to refer to it, which are irradiated fuel from the experiment, and that's going to be highly radioactive right there.
Okay.
So if you haven't examined for what the source of that was, and they didn't want to examine because they were worried about the presence of metallic sodium in these canisters. So if they were going to cut into these canisters that were in pits 35 and 36, and they did contain metallic sodium, they were worried about the risk of potential fire or explosion, depending on how these were cut up. So that was highly problematic, and they decided to leave them in place. So
I'll leave that topic. In your investigation, did you see in the Kennett report or in the documentation and accounting of the canisters, and could you give us a crude estimation of how many canisters you think there might have been produced over the 10 years of the experiments? You already mentioned that some went...
Let's stay with your question. Yeah. So do you have an estimate of the number of canisters?
As I recall, it's a little fuzzy. I think the Kennett report mentioned maybe 30 experiments, but I believe there were far more experiments than that conducted during the approximately 10-year course of these experiments.
Did Mr. Kennett see or verify the external location of any of these canisters?
And again, remember, I have the report, so I'll be able to look to see what it says.
To your recollection?
Not to my knowledge. There was nothing specific in terms of location that he identified, and we recently had an opportunity to speak with him.
Did he ever see a canister?
No.
Did he ever know what a canister was?
He may have, he may not have, but he certainly didn't indicate that he had seen one.
And in your looking at all of the data and the FOIA documents and so on, do you believe that we have, do we have an accounting of what happened to the canisters? Where they are, whether they were in storage or what fraction went in? Can we account for the 30-plus canisters physically? Do we have any information that does that?
I think he gets the question.
There were, in my reading of documents, and it seemed like there were places where there was some storage of these materials. that, you know, was not necessarily disposed of in the mixed waste landfill. But what we don't have is any kind of mass balance for how much of this plutonium or irradiated fuel or fresh fuel came to Sandia, how much of it is still intact and available in whatever portion is in storage, and do we have a missing and unaccounted for element of that material balance that we can't find in storage. That was never done. But it's clear, at least to me, from the many disposal sheets that have these acronyms related to the experiments, that you had experimental related waste going into the mixed waste landfill.
And in the canisters, do you recall that in some of the documentation, they said that some of the canisters were not, and this was previous Sandia information as well, some were post-mortem, if you will, examined, meaning they were presumably cut open, and some never were, implying that there may well be canisters in unknown locations that contain the entire, we'll call it package, because that's the definition Sandia uses.
Mr. McCoy, you can certainly answer that question, but again, gentlemen, you're asking me about documents that we've already talked about and that I've already seen and that I've already read. So you can answer the question, but please refrain from asking to just confirm testimony we've already heard. You can answer, Mr. McCoy.
The fact that they were worried about sodium in the canisters in pits 35 and 36 and didn't want to dig them up for that reason indicates that you had the LMFBR canisters, and if they didn't want to dig those up, they certainly wouldn't have wanted to dig up any of those types of canisters that might have been disposed of in the unclassified area trenches. And the fact that they would drill holes down in the bottom of those trenches would be an indication that they knew this stuff might be pretty hot, and so that would be my take on it.
And one last, if you'll indulge me, I'll try to put this in a question.
I think, was that to Mr. McCoy or to me?
No.
No. I will. I don't know about Mr. McCoy.
You will do last.
Go ahead, Mr. Dr. Nuttall.
Yeah, it's a little hard to put, I have to think about it and putting it in the question. Do we have did you see in the data sheets that you looked at, or is it possible that there aren't data sheets that showed the canisters that were put in implied to have been put into the small holes that may not have been ever opened, and that the packages, as we call the internal part, removed? Is that a possibility, that we don't have data sheets that show those, and that we showed that there definitely are canisters that weren't open?
Do you understand the question, Mr. McCoy?
I think I do.
Sorry.
Do you want to give me the short version of that question, if there is one?
Let me try to reframe that into a shorter term. Is it possible that canisters that were presumably put into the boreholes in the bottom of trenches, canisters that were unopened, and that the fuel elements, sodium, etc., was never removed from those canisters?
Well, I think it's possible, because they certainly didn't want to remove the sodium from the canisters in pits 35 and 36. Even if they had removed the contents of some of those packages, because some of them were light water reactor tests, even if they had removed some of the contents. I don't think they could have gotten all of the contents out of the canisters, because in a lot of those experiments you had vaporization of the fuel, and so you're going to have plating on the canisters. So maybe you can get some of the material out, but I think it's very doubtful that you would have gotten all of the material out. So you could still have a canister that was quite hot, containing.
That wasn't quite the question. Could they have put unopened canisters post-mortem into those vertical holes? In other words, we know that there were canisters that they didn't take the packages out of from the different documents. Could some of those canisters that contained the full experimental inner workings have been put into some of those?
Well, I think that's a
vertical
distinct
holes?
possibility. And I also think that there would be methods for checking just how hot some of this material is down in the bottom of those trenches, if it could be identified where those locations are. But you know, without that kind of certainty, who knows what's in that dump? I mean, that's the problem with this that makes it so unsafe, in my mind.
Well, thank you.
Okay. Again, remind the parties, new information, please. Mr. Wexler.
Thank you, Your Honor, and I will try and confine my questions to new information. One difficult thing at the end of the hearing, we've heard a lot of the same topics, and I'm not sure there were any brand new topics, but I will certainly try and contain my questions as much as possible. Good morning, Mr. McCoy.
Morning.
You did not provide a resume as part of your testimony, correct?
That's correct. I suppose the best source for the resume would be in the our objection to, removal here, and I verbally described my resume.
Yeah, so let's go through your background a little bit.
Okay.
My recollection from that discussion, which was the 2014 hearing on the facility-wide permit, right?
For Sandia Labs.
Yes.
Okay, yes,
You initially went to Occidental College, right?
I did.
What years was that?
1960 to 62, and then I went to Europe for a year, and I came back 63 to 64.
You didn't actually get a degree from Occidental?
No, I didn't get a degree from Occidental. I knew that Barack Obama was going to come along, and that would help the reference.
Well, that showed great foresight on your part in 1962. You did receive your Bachelor of Law degree from Western State University, right?
That's correct, yes.
And then you got your JD also from Western State University.
I did.
What year was that?
That was 1993, I believe, yeah.
You do not have a degree in engineering.
I do not have a degree in engineering.
Hydrology?
No, but I have done a considerable amount of study and review of hydrological concepts with Mr. Gilkison over the years.
Yeah, and we'll talk about your experience shortly. Do you have a degree in geology?
No,
Nuclear engineering?
no,
Soil science?
no.
Physics?
Do you want me to cut to the chase? I've got a law degree, okay?
Okay. No technical degree.
No, not to speak of, no.
Did you stay at a Holiday Inn Express last night? Just kidding. Turning to your professional experience, you have worked as a jazz musician, correct?
I have, yes.
What instrument?
Sax, clarinet, flute, piccolo, bass clarinet.
Do you still play?
Occasionally I get it out of the box and stare at it. Yes.
I'd like to hear it. You were a piano technician for a state university, correct?
I was, yes.
In fact, you had a certification in musical instrument repair.
I did. I do.
You've never worked as a regulator for NMED
No,
or any other agency?
no.
You've never worked at Sandia?
No,
You have never worked at a laboratory.
no.
You've never published a technical paper.
No, but I've written a lot of other types of articles and that kind of thing.
Any published in a technical journal.
No,
You've never been qualified as a technical expert.
I don't know. I gave technical testimony, as I recall, at the hazardous waste permit hearing for Los Alamos National Laboratories. That was around, if I'm recalling right, it's been 3 or 4 years since then. That was on particularly on legal aspects of the permitting process.
Are you referring to the 2014 hearing that was on Sandia National Lab?
No, I'm referring to the RCRA hazardous waste permit for Los Alamos National
Los Alamos.
Laboratories. I believe you were sitting there at that too.
Was that on, and you say that was on legal and regulatory issues,
That's correct, yes.
but not scientific issues?
No,
In your testimony, you discuss waste disposal, right?
yes,
Soil vapor,
yes,
chemical migration,
yes,
hydrology.
to some degree. Hydrology, yeah.
I do want to talk a little bit about the participation of citizen action in the 2004 hearing, and your position now is director. Is that what you are of Citizen
Executive
Action?
Director, correct.
Your predecessor was Sue Dayton.
Sue Dayton.
Uh,
And I wasn't at the 2004 hearings.
I understand. I do want to ask you a couple questions about that, and
Okay.
part of my purpose in this is actually I want to admit exhibits, DOE exhibits 12, 13, and 14. We can probably save some time. I can offer them now. If it doesn't work, then I can put in background on that. So I'll just offer DOE Sandia exhibits 12, 13, and 14, which are not in yet, although we have heard testimony about them.
Any objection?
I have one question about the offering of these. As I understand, the hearing officer had a findings. She did kind of 2 reports.
These are not those reports which are already part of this administrative record. I'll identify them for the transcript. DOE Sandia Exhibit 12 is the administrative record from the 2004 hearing, and there's a hearing exhibit book on the table there, Mr. McCoy, if you want to grab that. It's in volume 2.
And which exhibit?
12.
Or which number?
It's volume 2, exhibits 12, 13, and 14. Yes, right there.
And then just to continue again for the transcript, Exhibit 13 is the citizen action entry of appearance and notice of intent. Exhibit 14 is a document that was confirmed to be in the administrative record from that hearing that was submitted by Ms. Dayton, called Summary of Information Obtained under...
Okay, with that, they are admitted.
Thank you. And Mr. McCoy, you're aware that Citizen Action did participate in that hearing, correct?
I am.
You talked about the FOIA documents. I think you mentioned that some of the disposal sheets were missing. Was that your testimony?
Some of the disposal sheets were what?
Go ahead and re-ask the question.
Yeah. My understanding from your testimony was that you originally indicated that you were missing the FOIA documents from 1986 to 1988. Is that right?
From 1986 to 88, is that what you stated?
Yes.
Yeah, I never found any of those records, at least in this box. There may have been a scattering of them in the other box on the military side, but I really, there were no, see, most of these went up to They were in these folders, and they went up to 1985, and then there was nothing after 85 that I could get my hands on. And then subsequently, you guys provided a diskette of a CD-ROM of some other
Yeah, and so
documents.
recently you asked DOE and Sandia for those records, correct?
I'm sorry?
Recently you asked DOE and Sandia for those FOIA records,
Right, I believe that was at the negotiations.
and those were provided to you.
They were provided. I'm not sure if they were complete or not. I don't know.
Are you
So-
aware that those came from the Zimmerman Public Repository?
I'm not aware of that.
Have you checked the Zimmerman?
Yes, I've gone to the Zimmerman Library before, and it's an impossible experience to find the records or to get somebody to get them for you. It's beyond what the public can deal with, and I will compare that with the public records document area at the Idaho National Laboratories. You go in there, they've got a dedicated site where you can go in, all the documents are there. They've got a full-time librarian that will help you find the stuff. They've got a photocopy machine for it. This stuff, as somebody mentioned yesterday, James B. Arzi went in there to attempt to find some records and left in disgust.
So two things, Mr. McCoy. First, it's not your testimony that the FOIA documents are not in the Zimmerman repository, right?
That's not my testimony.
Yeah. So you do have concerns about Zimmerman. As part of the new permit renewal, there will be a community relations plan developed in August, correct?
I don't think Zimmerman is an appropriate location the way it's set up at present.
I
So
think the question was a little different, though.
Yeah, my only question is, you recognize there is a community relations plan that's being developed by Sandia, right?
yeah, I recognize that. That was one of the things I requested be done.
Yes, and that was made part of the permit, right?
That was one of the permit requirements to be done within 180 days after the
Are you aware?
decision on the permit.
Are you aware that as part of the community relations plan, they are working on the issues or concerns that you had about Zimmerman?
I've not been furnished any information to that.
Are you, well, it sounds like you haven't fully reviewed the FOIA records at Zimmerman, is that right?
Well, as I say, the Zimmerman experience has been so frustrating that I haven't bothered to go there. But I have reviewed these records,
Okay,
every one of them.
understood. Let's, hopefully we can do this quickly without having to look at all the documents. Exhibit 12 was the administrative, DOE Sandia Exhibit 12 was the administrative record from 2004. We can certainly look at this if you want. Do you recognize that the FOIA documents were part of the administrative record in 2004?
Do you want to direct my attention to a specific page?
Well, I was hoping to save time by confirming that, but page 103 of Exhibit 12. Do you have that before you?
What I've got is like page 2 of 114.
Yes, so page 103 of 114. The date on the left is 3/29/2004.
Okay. Page 103 of 144, or 144.
You have that before you?
I do.
Okay, first let's start with the second entry. From Citizen Action, Sue Dayton indicates the summary of information obtained under FOIA. You see that?
I do.
And that's a document that's
Are you saying that would be these documents? Because I disagree with that.
Okay, no, I believe that's DOE Sandia Exhibit 14. You're welcome to look at that and confirm that the title is the same.
I'm sorry,
Well,
you're asking?
Exhibit 14 is merely a summary of information obtained under the FOIA.
Correct. So you understand that to be the second entry on page 103 of DOE Sandia Exhibit 12?
If it's specifically referring to the summary. Right, but I wouldn't include these documents in that.
Fair enough. If you look
Summary.
on page 103 again and you go down 2 entries, also on 329 from Ms. Dayton, there's a subject, FOIA documents, with letter dated 3/29/2004. You see that?
I do.
You understand that to be FOIA documents submitted by Ms. Dayton?
Yeah, and I don't know, it's not specific enough to allow me to know what those documents were that were received.
Okay, let's, you understand that in the notice of intent, there are a number of FOIA documents listed. Why don't we just confirm that? This is DOE Sandia Exhibit 13. And if you, starting on page 3, you can see halfway down FOIA document 22, FOIA document 112, FOIA document 114. Do you see those?
I do.
If you turn the page, there's more FOIA documents, I believe. There's also a document entitled Nuttall, Eric, PhD, Sandia Mixed Waste Landfill, Nuclear Spent Fuel Disposal. That's a document we've discussed in this hearing, right?
Yes.
Up above there, the second entry is entitled New Mexico Environment Department Nuclear Fuel Assessment Project Summary.
I do see that. I see that.
Do you understand that to be the Kennett report? We can confirm the title of the Kennett
I
report.
do, and I'm not sure that the full report's ever been provided. There were photos that appeared to be missing.
Could you use the microphone?
I still haven't seen anything that would identify to me that these 2 boxes were in the records.
You have not taken the time to review the 2004 administrative record and compare it to your boxes, right?
No, what I've compared it to is the summary inventory.
You understand that the hearing officer discussed disposal records?
The what? Disposal record?
The hearing officer from 2004 discussed disposal records?
My understanding of the disposal record that you had before was that summary inventory list, not this.
Let me, Your Honor, may I approach? So, Mr. McCoy, I've handed you just one page from the transcript of proceedings. I don't want to belabor the point by going into too many pages. This is volume 1, indicates 2nd day of December 2004, a matter before Ms. Pruitt. You see that?
Mm-hmm.
And this is all part of that administrative record, so we don't need to
Counsel, is this the
enter
transcript
this.
from the hearing?
It is.
Okay.
I'm looking at page 113, which I've provided you. Midway down, and I'll represent to you, this is testimony from Richard E. Fate. Do you know who that is, Mr. McCoy?
No.
He was the project lead for the mixed waste landfill. Again, this is information that can be administratively noticed. It's part of that record. If you look, please, at lines 10 through 17, here, Mr. Fate is just one of the witnesses, is indicating We have a large body of historical records, certainly the radioactive material disposal forms, just stacks and stacks of those. Do you see that?
I do.
You
And that's Mr. Fate saying that?
Yes, it is.
Okay.
You understand that to be referencing the disposal forms?
It potentially is. I don't know that those were examined, though, by anybody else other than Mr. Fate.
Why don't we just, to confirm this, let's take a look at Exhibit 10, which is in Volume 1.
Okay.
Here we're talking about the waste inventory, and paragraph 43.
Paragraph 43.
Page 8. And it's talking about, we've heard testimony about this in this hearing. Sandia prepared a waste inventory made up of these disposal records and unclassified disposal records. You see that?
Okay, I see that.
And you understand that to include these disposal forms?
Yeah, that could include it.
When talking about
The claim is that it's the waste inventory for the landfill. I assume that's your summary waste inventory?
That's my understanding.
Okay. And so my contention has been all along that does not fully relate to these documents here. That it's
Okay.
incomplete information in the inventory.
But you will concede that the conclusion of the hearing officer and secretary was that the inventory was reasonable.
Was what?
Reasonably complete. We can look at the exact language if you want. It's paragraph 45 of that same document. The waste inventory is unlikely to be complete or completely accurate. However, it is reasonably complete and accurate considering the age of the records, length of time the landfill operated, and the types of waste routinely disposed of in the landfill. You do concede that was the finding of the secretary?
I concede that she found it is unlikely to be complete or completely accurate.
And Counsel, I think it says what it says.
Yeah, that's fine. You testified, Mr. McCoy, I believe, that there was information that's not totally clear on the disposal sheets, right? I think you were talking about acronyms.
Yes.
There's also other information that might be helpful to understand, like what the buildings, what activities took place in the buildings. Is that fair?
Yes.
And it's also helpful to understand what experiments are being referenced. Is that right?
That would be correct.
This is information that the DOE and Sandia staff is intimately familiar with, correct?
I wouldn't agree with that.
You talked, and very briefly, you talked a little bit about high-level waste, and I don't want to go into that. I did hear you referencing DOE Order 435.1, right?
Yes,
and
that's
will you concede that that is applicable to Sandia,
I believe it applies throughout the DOE,
including Sandia?
including Sandia.
You talked a little bit about the waste, even if it wasn't high-level waste. And my question is, do long-lived nuclides such as plutonium and uranium have to be disposed of in a geologic repository?
Well, you've got this business about less than 100 nanograms per gram, or that sort of business. But the problem that I see is that there's no comprehensive inventory of the plutonium. For example, this issue came up about the ITRI, 119 barrels of plutonium americium waste. There's no way to know that any estimate for that plutonium is correct. I mean, you've got an alpha contaminant, so it's inside a can, and you're not going to be able to measure the contents of how much alpha contamination there is from outside that can. So what you've got is an inventory that shows plutonium, but you don't know at what level. You can't track it. And we know that how toxic plutonium is. It's buried in shallow pits and trenches. It's stuff that you don't want people to be inhaling or consuming. So the reasonable conclusion there is put it into permanent isolation. Where there's uncertainty, you should be proactive towards the safety.
And I think the question that you're answering is more directed at Sandia, and my question is a little bit broader, and that just is, in general, setting aside Sandia, do long-lived nuclides such as plutonium, uranium have to be disposed in a geologic repository? I think the answer is no, and I'd like you to confirm that.
It depends on the concentration, but what I'm saying is that you don't know what those concentration levels are at the mixed waste landfill. And so your decision as to whether or not it should go into a long-term repository is not something that you can make based on the poor inventory records you've got for that substance.
We can look at the regs to determine what the requirements are. You talked a little bit about the Kennett report. Again, we can look and see what that says. We don't have to go into the substance. I do want to make sure that we keep the record clean here. You understand that there were two different reports. One was a Kilberry report done in, I believe, 2000, and then there's the Kennett report in 2003. You understand there's a distinction?
I do, and I also understand that the hearing officer was critical.
Yes, would you like to look at that language? If that's what you're looking for, I think I can help you. It's Exhibit 9, page 41.
Page 41?
Yes, sir.
Right, and so I go to the line, however, I was troubled by the Kilberry study in July 2000, which acknowledged that only 3 hours were spent comparing and tracing 36 items in landfill records that otherwise would take months to study.
Yes, I see that.
From this small sampling of records, NMED concluded that the classified records were sound, and Sandia knew how much of what went into the landfill over time. I was not convinced that enough was done in this area to verify these records and inventory, particularly given the significant amount of controversy surrounding the inventory raised by Citizens Action, the work panel, and the public. Then she goes on to say, however, in spite of this, so she leaps over her own insecurity about the thing, makes a decision that's going to affect potentially the lives of hundreds of thousands of people in Albuquerque. And I might add that this was an inside job. Ms. Pruitt worked for the NMED and still works for the NMED. So how would we expect an independent result to come out of this? I don't know. But she at least expressed her doubt about it, and I'll go with that rather than any security that you might be trying to find in her statement there, because this is not a good thing. And with the additional research that Dr. Nuttall and I have done on this matter, I think the record is even more clear now that you had high-level waste disposed of from nuclear experiments out there, and that may not have been clear to anybody given the time that they had before this public hearing took place. This is really complicated stuff, and I don't think Ms. Dayton was up to the examination of all these records from the time she got them to preparing for that hearing. But they at least raised a significant level of doubt, and I think that doubt still exists. And
Have you identified all the language you thought was important on that page?
yeah, I'm sure you found some more that you want me to look at.
No, I just want you to confirm that she's talking about the Kilberry study, right?
She's talking about the Kilberry study.
And not the Kennett report.
Well, let me double check that. She says she uses the word Kilberry. I believe I've seen Kennett Kilberry though in a hyphenated term in another document that she had.
The Kilberry study, as indicated in that paragraph, was done in
It's
July of
indicated
2000,
there,
right?
Yeah.
The Kilberry study was July of 2000?
In this particular document.
When was the Kennett report?
Kennett report. I'd have to look at
Does
the
2000
record. It would have been done considerably for this, but I would
Does
say
2003 sound correct for the Kennett report?
Perhaps it was done after Dr. Nuttall's white paper on the matter. Problem with the Kennett report is that
We've heard your
it
testimony.
didn't even refer
Stop.
to. You're saying stop to me?
No, Mr. Wexler, you please continue your
Yeah,
answer.
the Kennett report had numerous deficiencies in it, and one of those deficiencies was it didn't even relate to Dr. Nuttall's report, and didn't identify the experiments that were performed with the canisters and all the materials for disposal. It didn't trace all of that.
Mr. Wexler.
I don't think we need to go and look at the Kennett report. I think you and I disagree on this. Certainly the hearing officer can take a look at it. You understand in the 2004 hearing they did talk about some of the canisters and the experiments, right? In fact, Dr. Nuttall had some testimony about that, right?
In the hearing?
Yes.
Right, they discussed it. There was some discussion about that. I think it was, in terms of what we now know, it was a highly limited discussion that, given the presence of the high-level waste that we now know about
Mr. Wexler.
Yeah.
from disposal sheets.
Maybe we can wrap up this discussion by saying you were not satisfied with the Kilberry report, right?
With the Kilberry report?
Yes.
As I understand it, the Kilberry report devoted 3 hours to looking at records for the classified disposal area. And I've seen records for the classified disposal area that are so vague that one in the public or the regulator or the hearing officer couldn't possibly know what all's in the classified area.
So, Mr. McCoy, I think you're answering the question of why were you not satisfied with the Kilberry report. My only question is, were you satisfied with the Kilberry report?
How could one be satisfied with the Kilberry report? Even the hearing officer wasn't satisfied with it.
I think he's answered the question.
So the answer is no. Were you satisfied with the inventory that was done by Sandia? You were not satisfied with that either.
I was not, and over the course of the last few days, I've directed different witnesses to look at disposal sheets and ask them to find them in the inventory record, and they can't find them, and that included mercury and other nickel and other items.
You were also not satisfied with the RFI, right?
You're talking about the phase 1 or phase 2?
Both, the whole process.
No, by and large, I was not.
You were not satisfied by the Kennett report, correct?
No.
You were not satisfied by the 2004 findings?
Well, let's cut to the chase here, Mr. Wexler, because I'm not satisfied with any of this doesn't mean that I'm some kind of nut that can't be satisfied with anything. There's such poor data and such poor data collection methodology that was used for the phase 1 and phase 2, including the corrective measures study, that I've had other scientists look at this material, and I concur with them that the database is terrible.
Mr. McCoy, can we wait for a question, please?
Let's move on and just cover a few small issues. I'll only touch upon the ones that you talked about today, and stay away from the ones directly in your testimony. I think we've had plenty of testimony about the Tech Law report. You did talk a little bit about the groundwater issues. Starting with I guess you raised the issue of the mud rotary drilling, right?
Yes.
You are aware, are you not, that the monitoring wells in the LTMMP are BW1, MW7, MW8, and MW9?
That's correct.
What method did those use to be drilled?
They used the arch drilling method. And the arch drilling method, I might add, tends to compact formations. And there's evidence in the record that these were not drilled at the groundwater table as was ordered by Secretary Biarzi. The screens are 30 feet long, which is 20 feet longer than the EPA recommendation. And it's also longer than the requirements that were in the consent order to follow the EPA regulations, and those are at page 63 of the consent order.
Mr. McCoy, can you please answer the question? I promise I will give you a chance for redirect.
You're aware that the New Mexico Environment Department considers the groundwater monitoring to be adequate?
New Mexico Environment Department has not agreed particularly with the several of the wells that remain in that network to be correct, and that's from earlier writings. And monitoring wells 7, 8, and 9, although they consider them to be correct, I believe that they're technically incorrect, and so I don't agree with the New Mexico Environment Department, although I will admit that they think that it's adequate.
And we can always look at their testimony. I'm sure it's fully explanatory. The corrective measures implementation plan was submitted in 2005, correct?
Thereabouts.
There was an opportunity for public comment?
That's correct.
Citizen Action provided comments?
We did. You know, the problem with submitting public comment.
Sir, okay, just.
Well,
you can have an opportunity. I promise you will have an opportunity, but I want to get through the cross-examination, and you will certainly have an opportunity for redirect.
The CMI plan was approved?
It was.
The CMI report was submitted in January 2010?
Yes.
And there was an opportunity for comments?
Right.
Citizen Action provided comments, right?
We did.
And then that was approved in 2011?
Thereabouts.
It was in 2011, I believe, that the Environment Department, I'm looking at Exhibit 20, determined that the first 5-year plan was due 5 years after the approval of the LTMMP.
Yeah, you snuck that one past us.
That's correct.
That's correct. There was a lawsuit about that, too.
The LTMMP was submitted in 2012, is that correct?
No, it was first submitted in 2007, and it was withdrawn in 2011, I believe, and then resubmitted in 2012. So you had two versions of it.
You understand that the version that is applicable is the version that was submitted in 2012?
I do.
And when was that approved?
I don't recall the exact date on that.
There was an
But it
opportunity.
was
Yeah.
sometime after that.
I believe it's 2014. Does that sound right?
That was my basic recollection, 2014.
And in between then, there was an opportunity for comment, right?
There was.
Citizen Action provided
We
comments.
did.
No further questions.
Okay. We're going to take a 5-minute break. I have 10:36, so 10:41 we're going to start up.